Peter makes me look fat.
Peter adds 5 pounds. Oh, you must be on there about 10 times.
I know you're talking to him, not me.
2 people are entered. Okay, let's see who's there. Lisa Mitchell.
She's with Begerberg's office, but I don't think she's an attorney. I thought she was. I've got y'all's things on paper clipped on top of my dashboard for the rest of the week.
We still got bench problems after you appear, right?
Are they going to be still downstairs?
Yes. Judge Steinhauser's going to be there all day.
Okay,
You
then
don't
yes, we
figure
do.
all night.
Yes.
We'll see. I'm assuming Miss Mitchell. And so, say, Miss Mitchell, can you hear me?
Yes, I can. Good morning, Your Honor.
Okay, good. And so, Miss Mitchell, who are you associated with this?
I'm with the Office of the Attorney General. Nicole Fagerberg is who will be presenting this morning, and she's dialing in as well.
Okay. Well, we still have a few minutes, about 10 minutes before we're ready to go. I just wanted to figure out who everybody is.
Thank you.
So, Ms. Mitchell, do you anticipate giving either testimony or presenting any?
No, Your Honor. I'm actually working on the appeal in this case, and so I'm just observing at this point,
Okay.
if that's all right.
No problem at all. And then we also had Samantha Diaz. Do you know, is she going to be here?
She is no longer with our office, so she won't be here. Susan Bonin of our office may also sit in because she's also one of the appellate attorneys.
Is it Bonnan?
EN.
Okay. So we've still got about 7 minutes, so we'll just wait till 11 o'clock, or I guess until Ms. Fagerberg shows up, either way.
We were just emailing, so I'll shoot her another email right now and just make sure she's dialing in.
Okay. And then, see, Mr. Rothfelder, are you going to have anybody else here today? Okay.
No.
Okay. So if you can tell Ms. Fagerberg, there's no rush. But if she's ready, we could go ahead and get started. But she's not expected for another 7 minutes.
Okay. I just sent her a note and let her know that we're present and ready to go.
Since it's just a team, it's not too hot in here.
Yeah, no, it's gonna be okay. That's Ms. Bonham.
I heard from Ms. Bonin that she's in the waiting room, but I haven't heard from Nicole yet.
Let's see if I can let her in.
Mhm.
Not good. So can you see everybody?
Yes.
How have you been, Judge Leedy?
Doing well. So just hoping that the vaccine gets distributed and is a short-term relief for all of this.
Are you holding all of your hearings?
Uh-oh. And I just say, Mr. Rothfelder, I can see your lips moving, but I can't hear you.
Oh.
So I hope that there now I can.
Are you holding any in-person hearings or are all of yours now by Zoom like this?
We're doing both. Kind of give everybody the option. If anybody wants Zoom, you can, Zoom is the default position, but some attorneys say that they like to get out of their offices and just come up to the courthouse. So we have some.
I can relate to that.
Yeah, mainly, prove up divorces and probates and simple things like that.
Although all of our Harris County courts are closed.
Wow.
Everything's by Zoom.
He's going in and out.
Yeah. For quite a while, everybody sees me knocking on wood. Austin County, we've had a pretty low level of infections, and it's ticked up in about the past week, which, when you have a low number and it goes up even a few people, of course, now our percentages look terrible. So
Yeah.
the percentage of increase looks terrible. So.
It's pretty bad in Harris County. They have those different color levels, and we've been in the red level, the highest level, for weeks. I'm with you. I'm looking forward to that vaccine.
Okay. There's Ms. Fagerberg. Right. Okay, so we're not on the record yet, but I see that we have Mr. Rothfelder for SignAd, Ms. Fagerberg for the state, and then Ms. Mitchell and Ms. Bonin are here, and I understand they're not going to be speaking, just observing. So do we need anybody else to get started?
Judge, do we have a court reporter present?
We do. Yeah. She just waved.
Okay.
I saw her hand.
Yes. So yes, we do. And now I just saw somebody else, Elaine McClure, has clicked in.
She's my client, the general counsel for SignAd, Judge.
Let's see if we can admit her.
And she will not be participating, but only watching as well.
Oh. All right, so she should be in here now too. Okay, but yes, we do have Ms. Lozano is here as a court reporter, so we will go ahead then and get started. This is cause number 18CV-5774, the state of Texas versus SignAd Limited. We have everyone announce who's here.
Good morning, Your Honor. Richard Rothfelder for SignAd.
Judge, I'm Nicole Fagerberg. I'll be arguing the motion today for the state.
All right, so I show that there's two pending actions. One, SignAd has a motion to enforce, and the state then has a plea to the jurisdiction and a response to the motion to enforce. So, Mr. Rothfelder, I'll have you go first.
Thank you, Bill. Your Honor will recall that the state
Whoop,
filed.
And wait a second, and I'm not sure, you're kind of going in and out, so.
Your Honor will recall that the state filed this condemnation proceeding to accommodate its improvements to a bridge and other highway construction projects on I-10 near Sealy, which originally involved the billboard of my client, SignAd. SignAd incurred, however, over $200,000 in fees and expenses in moving the sign face that had an aerial encroachment on that bridge, moved that out of the right-of-way in accommodation of the highway and bridge improvements. The state then dismissed the proceeding and moved under 21.0195C for fees and expenses. And on September 14, 2020, the court ordered the state to pay $219,813 in expenses.
Yeah, I think what's happening is, I'm not sure if it's the microphone, but when you're looking right at the screen, we can hear you fine.
Yeah.
But when you move away, we can't hear, so.
Yeah. Okay. The court then, of course, filed its findings of fact and conclusions of law, and in its additional finding of fact number 7, the court noted that this allowance for condemnation fees and expenses were mandatory under 21.0195C. Now, here we are some 2 years later after the state filed its condemnation lawsuit, and the state has finished the work on that bridge out there in Sealy next to my client's sign. They got the benefit, obviously, of the work that SignAd did in accommodating the project, but they haven't paid the $219,000 order that Your Honor made back in September. And that is therefore the purpose of today's motion to enforce that SignAd. I should address, first of all, the state's argument that the court has no jurisdiction. It does, in that SignAd is not seeking to modify the existing order. It's merely seeking to enforce that order. And as we pointed out in our original motion and then in our reply, Your Honor, it's black letter law that a trial court retains statutory and inherent authority to enforce its judgment, even after its plenary jurisdiction has expired, citing the versus Timber case. Also, it's black letter law that a trial court.
We need him to repeat that.
Yes.
Okay, if you can go back, like I said, when you turn away, we just can't hear anything. The court reporter can't get it down. So what you said prior to
I was
the.
reading from the Beluga versus Timber case that's cited in our reply, citing the black letter law that a trial court retains statutory and inherent authority to enforce a judgment even after jurisdiction expires.
And again, unfortunately, didn't hear anything after what?
go through that again. Citing Beluga versus Timber, a trial court retains statutory and inherent authority to enforce a judgment after plenary jurisdiction has expired. Black letter law, Judge. And indeed, the courts go even further and say that a trial court has an affirmative duty to enforce its own judgment. That's a quote from the Crow-Billingsley case that's also cited in our reply brief. So there should be no doubt, since this is not any sort of request for modification, and instead is one of those situations where we're simply seeking the court to enforce its own judgment, where it indeed has an affirmative duty to do so, the court may continue to exercise its jurisdiction even after its plenary authority has expired. The state says that it's exempt from paying this judgment, but there's a state statute also in the Texas Property Code that deals squarely with this subject, namely section 21.063 Property Code.
Whoops, we didn't get the number.
Section 21.063B in particular of the Texas Property Code, Judge, provides a court hearing an appeal from the decision of a trial court in a condemnation proceeding may not suspend the judgment of the trial court pending the appeal. Once again, a very straightforward statute.
We can't hear what you're saying.
I said that the statute, Judge, is straightforward and just contains three elements. Number one, a decision of the trial court, and of course, that was your decision in September awarding fees and expenses incurred in connection with the condemnation proceeding. Number two, there must be a condemnation proceeding, and of course, that is precisely what the state filed, a suit to condemn my property interests of SignAd. And then the last element, they may not suspend the enforcement of the judgment under those situations. Now, the state in their response, Judge, you saw, filed 2 century-old cases, Hornberger and Park. Those 100-year-old cases are not applicable to this situation and don't change that straightforward statutory construction of 21.063. Both of those cases, Judge, involve takings by the condemnor railroads of property by landowners where those landowners sought to enjoin the railroad from taking their property. Importantly, and indeed probably the most important part, in both cases, the railroad condemnors actually deposited into the court registry the market value for the landowner's property, whether that award for their property was from a commissioner's hearing or whether it was from a jury. The courts held in those cases that the landowners were protected because the condemnor railroads actually deposited the funds for the market value of the condemned property in exchange for possession of the property. Now, one of the cases even makes it very clear that this situation discussed in Hornberger and Park expressly does not apply to our situation. Our situation, most importantly, where there has been no protection of SignAd by a deposit of your order, your allowance for fees and expenses. So SignAd remains unprotected. In the Park case, Judge,
Park case.
I'm quoting from the Park case that they attached to their response. We do not hold that pending an appeal by the railroad company, the defendants in judgment would not be entitled to the benefits of the judgment. This question is not involved.
And I'm sorry, we missed, said, this judgment is not involved with what?
The court says we do not hold that pending an appeal by the railroad company, the defendants would not be entitled to the benefits of the judgment. This question is not involved.
I tell you what, we got, the court reporter can't hear what you're saying. I think this case may have been attached. Maybe if you can point me to the page.
Sure. Yeah. It's under the last head note.
We can't hear anything. We cannot hear what you're saying, Mr. Rothfeld.
Can you not hear me at all, or is it just?
I can hear you now.
Okay. Yeah, turn to the last page of the case, Judge, under footnote 535.
Now, is this the Hornberger or
Right.
Park?
This
Which
is
one?
Parks. And go to the very end of the case, Judge. And really, it's the second sentence from the last paragraph of the case in Parks.
So the last paragraph I show starts with, "We are cited by plaintiffs." Is that the paragraph I'm looking at?
Yeah. Go to the end of that paragraph, Judge,
All right.
and you can see the paragraph concludes, "We do not hold."
Okay, go ahead.
Yeah, we do not hold that pending an appeal by the railroad company, that defendant in judgment would not be entitled to the benefits of the judgment. This question is not involved in this appeal. But it is involved in this appeal, Judge, in this case, because in this case, by contrast, SignAd incurred over $200,000 in fees and expenses as a result of the condemnation case, as per your September 2020 order. SignAd expressly did so to accommodate the highway construction project and move the sign out of the right of way. As such, the state got the benefit of the work, similar to the state getting possession of the property in the Hornberger and the Parks case. But unlike the Hornberger and Parks case, SignAd is not protected by the deposit into the court registry of the market value of the property, which the railroad company did in those two cases. Instead, you've got a simple situation here, Judge, where the state got the benefit. The highway construction project was accommodated. Indeed, it's been completed, all at SignAd's expense. But SignAd, by contrast, has not been protected by any sort of deposit of the amount of your award like it was in the Parks and the Hornberger case. Those cases, therefore, are completely inapplicable. And indeed, the Parks case said that appeal does not involve the situation that we have in this particular case. So in conclusion, Judge, this is another example of the state taking a straightforward statute and attempting to read into that statute some sort of convoluted interpretation so that they don't have to comply with it. Just like at the hearing that we had last fall on the underlying issue of allowance for fees and expenses when the state dismissed their condemnation case, Your Honor found that it was a mandatory obligation for the state to comply and pay those fees and expenses. In this particular case, Section 21.063 of the Property Code is equally clear. We have a condemnation case, we have an order from the trial court, and we have a situation where the judgment is not to be stayed pending the appeal. A straightforward interpretation of that statute requires the state to pay the judgment at this time. And we've therefore included a proposed order that clarifies that the state is ordered to pay, and failing to do so within 30 days, the judgment will accrue at the maximum legal rate. Thank you, Judge.
All right, Ms. Fagerberg?
So, Judge, let me first start. Can you hear me? Because I'm also at home or in a place where I'm not sure how well the connection will be.
I heard you perfectly for what you just said.
Okay, great. So, Judge, let's start at the beginning. And I don't know if you've had an opportunity to read the pleading that we filed, but I'm going to go in the same exact order as our response. So, Judge, let me start off with the fact that our first concern is that this really isn't structured like a motion to compel, right? It's really structured as a modified order. If you look at the order you originally signed, and then you look at what he's urging now, he seems to really just be revising his order, right? SignAd does not have this structured as a motion to compel at all. It's structured as a modified order that now includes a time limitation. And my concern on this is that, I mean, first of all, as a technical matter, it's outside the jurisdiction of the court to do a modified order. This really is not structured, in my opinion, as a motion to compel. I think what he's really trying to do is get a second bite at the apple. He's not happy with the order he originally submitted. And so now he's saying, well, let me see if I can get a modified one and maybe set this up for a motion to compel. I'm not really sure, but either way, I'm not going to waive my objection to that. So I think it may sound like a silly argument or a technical argument, but my concern is it really is just a revised order from what you've already signed. If you compare the two, there's not very many differences with the exception of this additional time limitation on the state to pay. The second thing, let's go ahead and talk about the concept that SignAd is not protected while the state is filing an appeal on this. I mean, the state's already filed its appeal and the appeals, it's commenced now. I don't think it's even argued in his briefing that the state is normally entitled to this protection, and that the state doesn't have to file that supersedious bond. That to me seems already stipulated within his pleading. And it's common. I mean, in fact, I've never ever seen the state have to file a bond to go up on appeal or pay a judgment while we're on the appeal. To my knowledge, that's never happened. And Mr. Rotfelder can't cite you to any examples where it's ever happened for him anecdotally. He can't cite you to a single case where it's ever happened. His briefing is entirely devoid of any condemnation circumstances where this has ever happened, right? So there's all this discussion of my client's not protected, et cetera. But the state is obviously good for this judgment. There's no issue that the state's going to go bankrupt and we're not going to be able to make due on it once an appellate court figures out what the situation is. Okay. So I don't see that he has any harm or that this is any different than any other situation. And let me just say for the record, Mr. Rothfelder is testifying about the state of the bridge, and I'm going to have to object to that. I've not had the opportunity to inspect that, but I don't want him to be injecting factual testimony into the record that may not be accurate. So I object to any testimony about the status of the construction anyway. Let's talk then about whether or not the one argument he really has is, hey, let's read this 21.063 and that should trump anything else. Well, the problem is, first of all, I don't think 21.063 is applicable because it's applicable to a decision where there has been, I think, a successful condemnation. He says, well, normally people get a deposit. Judge, TxDOT would have been happy to deposit the money, but there was nothing there. I mean, as you probably remember from this case, because they moved it out before the date of take, meaning before we could make the deposit, I literally had no ability to condemn the property. He made the argument in his own pleadings, Judge. SignAd said, hey, you don't have a public purpose to condemn. And I had to agree. And ultimately, we had to dismiss our case. So I couldn't make a deposit for something that's not there. I can't pursue a condemnation for something that's not there and that's out of the path of the bridge. And so it was SignAd's election to move that sign. But the reality now is, now they're complaining, well, there's not a deposit, but it was due to their actions that the state couldn't make the deposit. But there was never possession of the sign in this case. And I believe, Judge, if you recall the testimony, I don't think anyone ever contested that the state ever even touched their sign. They touched it, I believe they moved it before the state even filed its condemnation petition. So I don't think the statute should apply, because what this really is a dismissal proceeding that doesn't have a possession of any real property involved. Now, let's talk about assuming you even reach 21.063. Is that even applicable? And Judge, we contend that it's not. And Mr. Rothfelder can't point to a single case. I mean, this statute or a predecessor thereof has been on the books for over 100 years, and he can't cite you to a single case where the state has been made to pay a judgment on a condemnation immediately after the condemnation, let alone a dismissal scenario where there was never possession. But under 21.063, if you read these cases, and Judge, they're complex factually, but essentially, if you read them, what it really seems to say is generally that the state should not be made to pay this. Well, a condemnor should not be made to pay this, because in these situations, the court looks at a scenario where a railroad was fighting a condemnee, and the condemnee went out and managed to get a writ of possession and was trying to basically evict the railroad from his property after a trial court judgment. Well, then the railroad got an injunction. And so again, very complex as you go through it, but effectively the court says, look, if you were to try to suspend this, that's an incredibly dangerous situation for the condemnor. And really, you could destroy the whole railroad, the whole subject matter of why the condemnation was needed in the first place. So in the areas we cite, the court discusses not only the fact that the statute can't really mean what it says in the most literal sense, that when we're talking about suspension, that suspension means you've got to allow the railroad to continue possessing the property while an appeal of the trial court goes up, right? Now, actually, it goes further than that. It actually says that you also can't actually make the railroad pay the full amount in the interim either. Because actually, when you start looking at the Supreme Court decision that affirmed that case, they actually discuss the fact that I believe the trial court's verdict was something like 4 times the amount of the special commissioner's hearing. So really, it's both. It's both possession and the amount. But I think reading these older cases, which frankly were the only ones I found on point, I found no negative case law on this point, Judge. I found not a single case in any of the head notes, and I skimmed every single head note there was to skim, by the way, Judge, on this statute, and I found none that had ever forced the state to pay pending an appeal. So I think if you look at this, this is clearly what the statute was meant to address. And so Mr. Rothfelder kind of picking out this one point, arguing that it applies to a total monetary judgment that had no equitable provision, I don't think it's a compelling argument without a single case. So from our perspective, there's a variety of problems here. So we're asserting a plea to the jurisdiction to the extent that, you know, we're having to make that plea. We don't believe it's a good order. We don't believe it's an enforcement order. And we don't believe that it's necessary. And we don't believe that 21.063 is implicated in the first place. And to the extent it is, it's just not what he says it is.
Mr.
May I
Rothfelder,
respond, Judge?
you may.
Now, first of all, as to the modification issue, council pretty much admitted that it's a throwaway. When you compare the two orders, that there's not much change. She chooses to call ours a modification, but there's not much change, Ms. Fagerberg, as you pointed out. Instead, it's a situation where we are bringing to the court's attention that the state has not complied with its September order, and the court always retains jurisdiction to enforce its own orders. And that's what our motion does. Seeks to enforce the order which the state has chosen not to comply with. Now, staying on the jurisdiction point just one more time. In our original motion, we concede that under the normal circumstance, the state may supersede by the filing of a notice of appeal.
I can't.
And we can't hear what you're saying now, Mr. Rothfelder.
I said, under normal circumstances, yes, Judge, the state may supersede the judgment by the filing of its notice of appeal. And in our original motion, we even brought to the court's attention the Amex case, where there's the quote that we had, unless a contrary intention is made known to the court, the state's notice of appeal operates as a supersedious. And expressly, Judge, the statute passed by the legislature, 21.063B, is such an indication of a contrary intention. In fact, I wrote it down. Ms. Fagerberg said, Mr. Rothfelder wants you to read the statute to say what it says. And she said, surely the statute cannot mean what it says, but that's exactly what we're urging, Judge. The statute is clear, it's unambiguous, and it simply provides, once again, that if there's a trial court order like yours in September, in a condemnation proceeding like this, the state may not supersede by the mere filing of its notice of appeal. And these two cases that they cite, including the Parks case, which expressly acknowledges it doesn't address the situation that we have here, they once again deal with the issue of possession of the property so that the condemnor, in those two cases, happens to be a railroad that wanted to lay railroad tracks, so that the condemnor could get possession of the property pending the appeal. But we don't have an issue regarding possession here. She would like for you
We can't hear what you're saying.
Yeah. We don't have a situation here.
We didn't hear any of that.
Okay. Well, I gotta take a look at this laptop. We'll be in better shape next time. Can you hear me, Judge?
I heard when you said, you hear me? But before that, I did not.
Okay. I was pointing out, Judge, that we do not have this issue of possession that the state would like to read into that statute. You won't see the word possession appearing anywhere in 21.063. It came up under those two cases decided over 100 years ago that the state relies upon. And the point was that the state could take possession and proceed with their project because in those cases, they were protecting the landowner by depositing the commissioner's or jury award. But there's no protection of SignAd in this case because they've refused to pay or deposit your award, Your Honor. So those cases are completely inapposite. And indeed, Ms. Fagerberg complains that we don't have any cases discussing the statute. She goes on to acknowledge that she found only those two cases that are a century old. And she complains that those two cases that are not on point were the only ones that she found and that I haven't cited in any cases. And the reason is that there are no cases on this unusual situation. So we rely upon the statutory construction that says when there's a straightforward, unequivocal statutory language, the court should construe it as such. And it simply requires, in this case, a trial court order in a condemnation proceeding. Under such situations, the judgment shall not be superseded. And as such, as I said, the court should enforce its prior order in this particular case, Judge.
All right. All right. Well, just based on the argument today, the SignAd's motion to enforce is denied. And anything else today?
I don't believe so, Judge.
All right. Thank you. Then you're all excused and hope everybody stays safe out there.
Thank you, Judge.
Okay. Bye-bye.
You too.